Hello, welcome to this webinar on the Uninterrupted Scholars Act. The webinar will be jointly presented by the U.S. Department of Education and the U.S. Department of Human Services. We've muted participants for today's session. However, you may enter questions into the chat box in the lower corner of your browser with questions. While we will not be answering questions today, we will take these questions forward to provide further clarification to upcoming publications around this topic. You can also send questions to privacyta@ed.gov. This webinar will be recorded and posted on both the Family Policy Compliance Office websites as well as the PTAC website. Those links will be provided at the end of the webinar. Talking about foster children, the program basics and why it's important to share information, the Federal Child Welfare Law, FERPA 1, the Uninterrupted Scholars Act. Then we'll talk about specifics with some common scenarios and where you can get help. Presenters from the U.S. Department of Health and Human Services are Taffy Campaign from the National Foster Care Specialist, Elizabeth Leonard from the Policy Division, from the Department of Education, Dale King, the Director of the Family Policy Compliance Office, as well as Baron Rodriguez from the Privacy Technical Assistance Center. I'm going to hand it over to the Department of Human Services, and they can take it from here. So just one moment.
Access to the desktop?
Hi, this is Liz. Yes, I do. I'm just waiting for it to load right now. All right, there we go. Are you happy?
At the Children's Bureau at the Administration of for Children and Families. And what we'd like to start off with this afternoon is giving you a very, very quick, high-level overview of the foster care system so that hopefully we can give you just a little bit of insight into the journey of a child being in foster care, and then particularly why it is that we see that school stability is so important for the children that are in foster care. Thoroughly, the way that the children come into foster care is first there being a contact, typically a report of child abuse or neglect. States will have abuse hotlines. There are people who will call from family members, interested parties, even those that may be considered to be mandated reporters, such as school teachers, and there is investigation that is made into the specific situation based on the details that are gathered. And in that investigation, the risk and safety of the child is assessed. Based on that assessment, which includes interviews with the child, if appropriate, with family members and those involved parties and even others. But from that assessment, a determination is made as to whether there should be a recommendation to the court that the child be removed from home or not. Of course, we try as much as possible to be able to maintain the child in the home, for example, with appropriate services that would ensure that the child can be safe while we work with the parents on the particular issues. And that would really be the parents or whatever caregiver it is that the child is with. But there are times when the child does have to be removed in order to ensure their safety and well-being. And in those cases, we will have various placement options for the child. Again, So this could include a foster home, and so the state child welfare systems will have a myriad of foster homes that are able to receive children that are not related to them and to give them a placement while we work with the family to hopefully return the child to their home. Oftentimes, very often as well, we are able to find relatives who are able and willing to care for the child on a temporary basis and work with family and work with the agency to try to help return that child home. So that's another placement option. And sometimes, the child is determined to be able to be, by the court, to be able to be in the home with or without services. So one of those placements or one of those situations may be used. And then when the child is actually placed in foster care, the court will, on a periodic basis, review that child's case. At least every 12 months, there needs to be a permanency hearing to really look at the specifics of that child's situation, what their goal is, and how the family, the agency, and the other involved parties are progressing towards having that child's goal met so they can achieve permanency. And so again, when the court is doing those reviews, they may choose to remain the child in foster care while they're looking for other permanent options. They look at terminating parental rights, which then means that the child is in a situation where we are looking for an adoptive home or that we give custody to another caregiver. And what we would really want to happen, and does happen about half of the time, is that the family is able to complete their case plan, that is a set of goals that there are for the return of the child. They're able to complete those successfully, and the child is able to be reunified. So those are the various options of what might happen in the life of a foster child, and oftentimes there can be an intertwining of various different types of placements and different types of goals while the child is in foster care, which may include changing placements to where it also would create a change in the school setting for the child, and that's why we want to talk about educational stability. Next slide, please. Okay, so here are some numbers around children that are in foster care, and I believe that these are from September of '09. I do have pretty similar but more recent numbers based on what we call AFCARS data, and that's the Adoptions and Foster Care Analysis and Reporting System, really a long name to say it is a data collection system in which the state's child welfare agencies report to the federal government on various components of their child welfare system. So in September 30th of 2011, so forward 2 years to the information that we have here, we had just over 400,000 children that were actually in foster care. So they were removed from their homes and they were in foster care. Breakdown around the ages that you see here, percentages are very similar even in 2011. So your vast majority, 65 to 70% of your children that are in foster care are school-aged children and youth between the ages of 5 and 17 years of age. Next slide. And actually also additional information, the 2011 data showed that for children in foster care, 52% were male and 48% were female. And about 47%, so almost half of those children were actually placed in foster homes with a person who was not related to them. But also just over half of the kids in foster care, about 52%, had a goal to be reunified with their parents or their principal caregiver. So for these children in foster care, there are concerns for their educational stability, and it's evidenced by a couple of different statistics. I think there's is there a slide right before this one? I think this is the first one. Thank you. So one of the concerns for the children in foster care is that they are more likely to have repeated a grade. And so here you see information from three different sources. I give you a picture from across the nation. L.A. Chapin Hall is looking at the Chicago public school system, and then also for New York. And in all three of those cases, what we basically see is that the children do have to repeat some of their grades and some of their schooling. In the Chicago public school system, we saw they were twice, the children in foster care were twice likely as their students to have to repeat a grade. Would you go to the next slide, please? Concern that we have is that these children often have to make multiple placement movements. So they may be in a foster home, and for many different circumstances, they may have to be moved to another foster home, or perhaps a relative has come forward and has said that they're willing to take care of the child. And so then we would make a placement with a relative, as that puts them closer to where they have connections and where they have family. But that move could mean yet moving to another school. So there's a high rate of mobility. As you see, there's an average of 1 to 2 home placements per year while they're in out-of-home care. And in particular, the third bullet, we've done a lot of work looking at this Midwest evaluation study, which also comes from Chapin Hall in Chicago. And for those three Midwest states, over a third of the young adults reported having had 5 or more school changes in their time in foster care. So as we see, they do tend to move around a lot, and that means having to make new connections, ensuring that their school records are transferred timely. We often have to look at what the transportation situation may be, and it's all very case-by-case dependent. Next slide. One concern that we have is that unfortunately children in foster care tend to be overrepresented in the educational achievement gaps. And so we give you 3 examples there. I'm not going to read them all individually to you, but you see 3 examples there of their scoring below their non-foster care counterparts in standardized tests, and overall attending lower achieving schools than other children. And also typically reading at a lower level than their school grade. If you'll go on to the next slide. So some of in the educational outcomes, as you can see, what we're showing you here is that while students that are in foster care tend to drop out at a higher rate than those in the general population, they also tend to not do as well as the students in the general population when it comes to really graduating from high school. And as you can see, there's a very big gap, about 40% difference as to how many go on to college. And again, a gap in how many graduate from college as opposed to the general population. So those things that we can do while they are in high school to try to prevent that dropout and to try to really support they're going on to college and doing so successfully, the things that we're really looking at when we think about their educational stability and well-being. If you'll go to the next slide. I think that there was one piece that I did not note, but we do a lot of work with youth that are former foster youth. We call them alumni of care. And these alumni, by and large, they're very interested in being able to go to college and really want to be able to be successful in college. So it's not as much an issue as we see as far as their interest, but it is a lot of the environmental factors and a lot of the issues that they have to deal with in not being placed in their homes of origin, and in dealing with the issues of the abuse or neglect that they may have suffered, that really impacts their ability to go on to college. And as you see, in addition to that time period where they're transitioning from being children and youth to be young adults, and how the instability or the issues that there might be from having many placement changes and being at numerous schools, etc., we see that impacts their ability and their time in that second or that higher education time period, but also even thereafter as adults. As you can see, students that were in foster care tend to have less ability to actually have insurance, and yet have a lot higher propensity of having mental health issues. There is a much higher level of homelessness and also of living below the poverty line when they are adults, as opposed to their counterparts from the general population. So this kind of tells you the story very quickly of Intercare, that can look in many different ways as far as where they're placed, and that even throughout the time that they are in foster care, they can be in many foster care placement settings. And that unfortunately the instability of being in foster care it can lend to there also being a number of issues for them later on in life. It'll go on to the next slide. So why we think that school stability is so important, and we want to talk about that and how this particular law has supported that, is because over half, about 60% of the children that come into foster care do return to their homes of origin. They return to their parents, to their original communities, to their original schools. Those that did not have as much stability in their school setting have shown to have had much more academic delays than, for example, those that were able to remain in their same school or may have only had one placement change, have shown to have then less issues in the transitioning back to that school of origin. We think that a very important factor around maintaining school stability while they are in foster care is that they are dealing with so many issues during that time. They're placed away from their homes, so there's not a level of permanency in their lives. They consider the placements where they are often to be temporary, and have a lot of anxiety around what that means and what does tomorrow hold. Will I get to go home or not? And they're also very much dealing for quite some time with the trauma of whatever abuse and neglect they suffered, as well as the separation, which is not just from their parents, but oftentimes they could be separated from siblings, or they could be separated from their communities, such as their friends in school, and that really is a big impact on these children, a lot of issues to deal with. So we think that we really promote the stability in their school system as a positive counterweight to having to deal with so many issues at such a young age. Elizabeth, next slide. And so with that, I'm going to turn it over to Elizabeth. I'll let her introduce herself, but she'll talk a little bit from the standpoint of the federal child welfare funding and laws that also impact this issue. Elizabeth?
Hi, Taffy. This is Elizabeth Luffner. I work in the Children's Bureau in the Policy Division. And Taffy just did a great job of discussing why children in foster care have a lot of these educational challenges. They're changing schools, they're changing placements, they're repeating classes, they're falling behind, and you all know this. But from our perspective, the child welfare agencies have the primary responsibility for the well-being of these children when they're in foster care. And what comes along with that are certain federal requirements for not just the general well-being and safety of those children, but also their educational success. To provide today is a general overview of the child welfare funding, and also those requirements in law that are linked to that federal funding. So our agencies can be operated by states, tribes, and local agencies. Agencies receive funding from a wide variety of sources, including state, tribal, and local sources. And of course, the big piece of that is also federal programs. The two biggest sources of child welfare funding from the federal government are Title 4B and 4E of the Social Security Act. Funding is a variety of discretionary and mandatory funding, and it's flexible funding that's distributed to state and tribal child welfare agencies based on a formula set in law. Now, this funding is available for a wide variety of activities, from family probation to hopefully prevent the child going into foster care, generally promoting safety, permanency, and well-being for children in foster care and adoptive families, and improving outcomes for children affected by substance abuse, and even more. It's a broad pot of money. It is a little different. It's not like the flexible funding under Title 4B. It's reimbursement for payments and administrative costs only for eligible children. Anyone that might be in foster care and have been adopted or be in a relative guardianship. And these children are for maintenance for the foster care, for adoption assistance payments, guardianship assistance payments, and also the associated administrative and training costs. Funding for child welfare programs available under the Child Abuse Prevention and Treatment Act and Safety Foster Care Independence Program, but I'll talk about those so much today because I want to get into the requirements that apply to those agencies getting the Title 4B and 4E money related to education. So just that's where the link is for these requirements. Child welfare agency workers develop a written case plan for each child in foster care, no more than 6 days after that child was removed from their home. The case plan has lots of components, and they're all related to ensuring the safety, permanency, and well-being of the child. But relevant required components today that we're talking about is around the child's education records. So this information that you see on the slide, at a minimum, included in that written case plan. The child welfare agency workers need to review and update that education record each time the child's placed. It has to be provided to the foster parent. And eventually, if the child care at the age of majority in the state, the agency should be providing those full education records to the child. So as you can see, child welfare agency access to education records really helps ensure that the foster care provider is up to date with a child's educational needs, and it can help a youth leaving foster care make sure that they have easy access to the records for their own use as they go forward towards independence. Including the child's education records in the case plan, the welfare agency must address the child's educational stability in the case plan. An educational stability requirement means that when a child is being placed in foster care from their home, or if they're already in foster care but they're moving to a new placement, the agency has to do certain things. They have to consider whether the child's current school is appropriate. They have to consider how close the current school will be to that new foster care placement. And they need to be coordinating with the local education agency to work to keep the child enrolled in the same school. And that would be through transportation and also, of course, coordinating with the local education agency to make sure that their records get over and that they can actually be enrolled in a timely manner. No, it might not be in the child's best interest to stay in the same school sometimes. So, for example, there could be an extremely long travel time, there could be safety concerns at the school, or it might be a special program at a different school that's more appropriate for the child's needs. In that case, if the agency determines that it's not in the child's best interest in the same school, the agency has to make sure that the child is immediately enrolled in a new school and their records are provided to the new school. Really depend on the timely access to those education records to make those placement decisions to ensure that they can determine the best interests of the child and, of course, minimize disruptions to the child's education. I'm going to speak to is around school enrollment. So our agencies receiving this 4E and 4B funding have to ensure that each child getting a foster care payment is a full-time elementary or secondary school student. And with this requirement in law, we also encourage child welfare agencies to ensure that they're not just enrolled, but that these kids are actually attending school. So earlier, child welfare agencies do have the primary responsibility for the well-being of these children in foster care. So we really encourage agencies to keep up with this requirement and ensure that they're not just enrolled, but they're also attending school. And access to the education records of children in foster care, that really helps the child welfare agencies verify that enrollment and attendance. And to say today on the federal child welfare requirements around education. I believe the next slide goes to back to education. And thank you for your time today.
Thank you both. And now we're going to transition and talk a little bit about FERPA basics and then start to talk about some of the specifics around the changes enacted by the Uninterrupted Scholars Act. So with that, the Foundational Rights and Privacy Act, here's the statute and regulations. And as many of you already know, the regulations were changed effective January 3rd of 2012. And if you look at some of our past webinars, we kind of go through a summary of those changes. We're also dealing a little bit with a legal challenge from the EPIC, which is the Education. Yeah, sorry. Education, Privacy, and Information Center, I think it is, and versus the U.S. Department of Education, which has created some challenges around data sharing, and we'll be talking more about that probably in the future. But what is FERPA? FERPA gives parents and eligible students the right to access and to seek to amend education records. It also protects personally identifiable information from education records from unauthorized disclosure. And written consent is required to disclose PII unless one of the exceptions apply. So what are education records? Education records are those that are directly related to a student and maintained by an educational agency or institution or by a party acting for the agency or institution. Keep in mind that behavior and suspension records are also included in the definition of education records. What is PII? PII can be many things. Name, mother's maiden name, address, date of birth, social security number, parent's name. Also, it can be information that could not be directly identifiable, but when combined with other information, can become personally identifiable information. So, for instance, if you link together some of these pieces, some non-identifiable data, if there's small subgroups, for instance, that can make that information personally identifiable information. What are some of the exceptions to the consent requirement? Some of the exceptions include school officials with legitimate educational interests, schools in which a student seeks or intends to enroll, state officials pursuant to a state statute in connection with serving the student under the juvenile justice system to complete judicial order or subpoena, evaluations and studies, directory information, and health and safety emergencies. Education program. Education program is any program principally engaged in the provision of education, including but not limited to early childhood education, elementary and secondary education, post-secondary education, special education, job training, career technical education, and adult education. It also includes any program that is administered by an educational agency or institution.
Thanks, Baron. Again, my name is Dale King, and I'm the Director of the Family Policy Compliance Office, and it's the office that's responsible for enforcing and implementing the FERPA. And I know Baron just gave you a very quick overview, of course, of some of the key terms in FERPA, and I know most of the folks out there probably are aware that FERPA is much more complicated and much more detailed than those four definitions. But what I want to talk about is really going into what does the Uninterrupted Scholars Act do? How does it impact FERPA? But before we talk about what it does, I wanted to sort of talk about, well, what has it been like prior to what was it like prior to the Uninterrupted Scholars Act? And I think Taffy and Elizabeth provided you a very good overview of the need for education records, that because these students that are in foster care, it's a very unstable situation. They're moving from maybe one foster home to another. So there's this need to have access to education records in order to assist those students. So, but you remember that prior to Uninterrupted Scholars Act, and remember that under FERPA, the requirement is that you have to have written consent from your parent or an eligible student. And I know there are many that are an eligible student is someone who's 18 or older, and that's a small population. So I'm probably going to be talking more just in reference to the parent and not the eligible student. But that you have to get consent from the parent. I mean, in the case is the foster parent, or you get consent or had to go to get a court order in order to be able to disclose those records to a child welfare agency. And so that was always been a challenge, I know, for foster care agency or for the child welfare agency in obtaining those records. And I think one thing that also contributed to some of the confusion in terms of the difficulty in this kind of cooperation between education agencies or the schools and child welfare agencies was when Congress passed the Fostering Connections to Success and Increasing Adoptions Act in 2008, which is the Fostering Connections Act. The act gave the state child welfare agencies the responsibility of working with the LEAs to implement the educational stability requirements, which Elizabeth was talking about, for those children in foster care. However, what Congress did not do at that time was they did not amend FERPA to permit LEAs or the schools to disclose those students' education records, except in accordance with FERPA, which again would have been either through consent or one of the other exceptions, which was generally a court order. So while the Fostering Connections Act talked about coordination between schools and the child welfare agency, privacy provisions in FERPA were still applied, which made it much more difficult then for the agencies to meet their responsibilities under the Fostering Connections Act. So with the passage of the Uninterrupted Scholars Act, FERPA permits disclosures without consent, education records of students in foster care to those representatives of a state or county child welfare agency who are asked to access the student's case plan. Okay. So what has changed? Well, of course, the Uninterrupted Scholars Act specifically changed or amended the Family Educational Rights and Privacy Act, which we refer to as FERPA. And specifically what the Uninterrupted Scholars Act adds is an additional exception to the requirements of consent in FERPA that permits the schools to disclose education records of students without parental consent to agency caseworker or other representative of that state or local child welfare agency, also to a tribal organization, because the Act does apply to tribal organizations that are authorized to access a student's case plan. Such agency or organization is legally responsible for that in accordance with the state or tribal law for the care and protection of that student. Now, exceptions to the general consent requirements are in our FERPA regulations. However, here at the federal government, we're not that fast, so you will not find this new exception under the Uninterrupted Scholars Act. You will not find that in our regulations, but it definitely does apply. And you also remember that the exceptions to the general consent requirements in FERPA, including the new exception under the Uninterrupted Scholars Act, are permissive and not required. There's nothing in the Act that would require a school or LEA to disclose any education records to the Child Welfare Agency. However, the Department encourages both HHS and the Department of Ed highly encourage such cooperation. And again, this is something that's also required under the Fostering Connections Act. Next slide. So think about what can child welfare agencies do with the education records. The Uninterrupted Scholar Act does permit a child welfare agency to use PII from the education records for a very limited purpose. The language is very specific. The Act provides that disclosure or any redisclosure may be made to an individual or entity that's engaged in addressing the student's education needs, and that's authorized by the agency organization to receive those disclosures, and those disclosures that there is consistent with state and local, state tribal laws that are applicable to protecting the confidentiality of students' education records. Now, just a note that while FERPA does require the school to record the disclosure of education records that it made to the Child Welfare Agency, that FERPA does not require the Child Welfare Agency to record any disclosure of the personally identifiable information, or PII, from the education records that it makes, for example, to other individual entities, such as a contractor who may be providing services to address a foster student's education needs. In addition, which is a little bit different, really doesn't apply to welfare agencies, but the Uninterrupted Scholars Act also amended the exception to the general requirement of consent in FERPA that permits a school's disclosure of PI from a student's education records without consent, if disclosure is necessary to comply with a lawfully issued subpoena or judicial order. Under FERPA, generally, it requires that schools to make a reasonable effort to notify the parent or eligible student of the subpoena or judicial order before complying with it, in order to allow that parent to seek to quash the subpoena order or seek a protective action. However, the Uninterrupted Scholars Act amended this notification requirement, adding an additional exception that a school or LEA does not have to notify a parent if the court has already given the parent such notice. Okay, next slide. Permitted sharing. What about the sharing to address educational needs? Let's talk a little bit about what it, again, when I think we've talked about this, that what is the Uninterrupted Scholars Act permits the use of this data. It is clear, the Act is clear that the education records disclosed to the Child Welfare Agency under this exception must only be used to address the education needs of the child. Further, unless a school permits the Child Welfare Agency to use the PII from the education records pursuant to the other exceptions under FERPA, the Child Welfare Agency could not use the information from the education record it received under this exception for any other purpose. For example, I mean, it would be permissible here that an LEA may want to evaluate the effectiveness of its education programs in meeting the needs of children in foster care, and it may want to use the audit evaluation exception under FERPA to conduct such an audit or an evaluation. Now, it's important to stress that Congress intended that the Uninterrupted Scholars Act only apply to those children where the Child Welfare Agency is legally responsible for making the legal decisions for the child relative to foster care. Thus, the Act would not permit schools, LEAs, to disclose the PII education records for children who receive other services through the Child Welfare Agency if the parent or guardian retains legal responsibility for their child. For example, some agencies I know may be providing some kind of vocational skill assessments, or they may be providing family services, and the student and child is still under the legal responsibility of the parent or guardian. So in those situations, this exception would not apply. I think that sort of covers the basics of the changes as a result of the Uninterrupted Scholars Act, and I think we're going to move now to some just sort of common scenarios that may be helpful.
Great. Dale, what if a high school gets a request from the local child welfare agency for all school records related to certain students who are in foster care? Does the high school have to turn over all of these records, or just the information the high school thinks the child welfare agency needs to see?
Well, actually, FERPA doesn't require the high school to turn over any of the records to the Child Welfare Agency. Again, FERPA permits the high school to turn over all or part of the education records for those students in foster care to the Child Welfare Agency that is responsible for their care and protection. And the agency may use these records to address the student's educational need. However, again, it highly encourages schools and LEAs to share education records to the welfare agency for those children that are in foster care.
So schools sharing education records with a CWA need to have a written agreement with that agency prior to disclosing PII from education records?
Not under this new exception that's created by the Uninterrupted Scholars Act. There are other FERPA exceptions that do require written agreements, but it does not apply in this particular situation. However, FERPA wouldn't preclude a school or an LEA from having some kind of a written agreement with the welfare agency, but would not require it.
If the CWA hires contractors to function as caseworkers rather than using its own employees, may CWA redisclose education records in this case, to those contractors? And if so, does the CWA have to record the redisclosure?
Well, yes. The Uninterrupted Scholars Act, and from this point on, I'm going to say USA because I'm getting tired of saying Uninterrupted Scholars Act, it does authorize the Child Welfare Agency to redisclose the records, but it's only to an individual or entity engaged in addressing the student's education needs. And the redisclosure has to be consistent with state or tribal laws. And while USA doesn't require the welfare agency to record the redisclosure to the contractor, both HS and the Department of Ed think it's a good practice to record this disclosure.
So does CWA use education records for purposes other than addressing a foster child's education needs? For example, could the agency use these records to conduct investigations of child abuse or conduct research, for instance?
Well, I think as we've pointed out several times already, that under this exception to FERPA, the welfare agency can only use the education records to address the student's education needs. Now, there are other exceptions. They permit the Child Welfare Agency to obtain and use PII from education records for other purposes, but those circumstances are not being addressed. We're not addressing those in this webinar, but you could find out more information about these other exceptions through our technical assistance resources, and I think we'll mention those at the end of the presentation.
When a school district is willing to turn education records to a child welfare agency, but wants to require the CWA to destroy the records once the children in question are no longer in the foster care system, does FERPA require this, and can a school district make the CWA do this?
Well, some of the exceptions do require the recipient of education records to destroy the information when it's no longer needed, but that isn't true under this exception. It's really up to the school district and the CWA to determine how long the CWA will keep those education records. As a good practice, the CWA could use its standard record retention guidelines unless the CWA and the district agree to something different. Just one thing to remember, though, that if the welfare agency does retain those records, that it cannot use the information in those records for any other purpose.
An LEA, so a district, for instance, and a CWA agree to enter into an arrangement where the LEA sends information on children in foster care to the CWA on a monthly basis?
Sure. I mean, they could do that. As best practice, both HHS and ED would urge that the CWA identify the students in foster care for each delivery so that education records are only delivered for students who are in foster care at the time the records are transferred. But just don't forget, though, that LEA and the school must record these disclosures if they do set up such a practice.
What does school do if it is notified that a child is in foster care and then the biological parents asked to meet with the child's teacher and review the student's progress? Does FERPA mean that the school can no longer talk to the biological parent?
Usually. I mean, as parental rights are not automatically terminated for all children in foster care, in those cases, the goal for children is to return them from foster care to their families, and it can help for the biological parent to be involved in the child's schooling. However, if a school has evidence that parents' parental rights have been terminated, then FERPA would no longer provide that parent with any rights, and the school would not be permitted non-consently to share education records with that parent. We encourage schools to learn about their student situation and to be sensitive to whether involvement with the parent is safe.
What about situations where the child is living with a relative because the home situation is unsafe? Can the school share records with the relative?
Well, I mean, I know we have this question in here, but this is really about the USA or foster care, but this is a question that we get fairly regularly. And the answer is that generally FERPA would permit this if the relative is providing day-to-day care for the child. This would be true regardless of whether the arrangement is an informal one, or whether the relative has been appointed as the child's foster parent.
Let's say it shares education records with the child welfare agency and the CWA inappropriately shares these records with the press. Is the CWA potentially subject to FERPA's 5-year rule so that the CWA can't get records from the district for 5 years?
Yes, I'm sure that there would not be an agency out there that probably would do this, but yes, it would apply. But you have to remember that it's only the department, only my office, the Family Policy Compliance Office, that would have the authority to impose that 5-year rule. Now, a district may not be willing to continue sharing records for foster children with a CWA that inappropriately discloses those records. So remember that data sharing with anyone other than the parent or the eligible student is permissive under FERPA, and again, not mandatory.
That's a good reminder. Decide to share education records for children in foster care and send records to the child welfare agency directly from the state education agency rather from individual schools and LEAs?
Sure, yes. It's up to the SEAs and the LEAs to determine what is the most efficient way to share this information with the CWAs in the state. So vary in where they hold education records and how frequently they update them. So there's no single right way to do this, but again, remember that regardless of which entity shares those education records with the welfare agency, the disclosure has to be recorded.
Normally, FERPA requires schools to record disclosures. Do schools need to record disclosures to child welfare agencies?
Well, you've answered this one probably 5 times, and we're making this a very important point. So yes, they do need to record the disclosure to the child welfare agencies.
Can schools also disclose special education records to CWAs, such as individual education programs, also known as IEPs, under this exception?
Yes. Special ed records may be disclosed. In fact, child welfare agencies will often want those IEPs more than probably the other education records so that they can help facilitate services for the children if he or she changes a school.
The appropriate CWA representative asked to receive education records for children that it is helping with an in-home services, so children who are not in foster care. Does the Uninterrupted Scholars Act allow the school to turn over these records?
Generally not. The question is whether the welfare agency is legally responsible in accordance with state or tribal law for the care and protection of the student. And this will almost always mean that a court order has been entered placing the child in the care of the state or the child welfare agency. If that's happened, then the U.S. allows the school to turn over records for as long as the child is in the care of the state or the CWA. The U.S. does not apply to education records for children whose families are receiving in-home services. It only applies to those children in foster care. Now, in some instances, however, a child in foster care will be returned to his or her family home for a trial period. At that time, the child is still in the care of the state, and the school could continue to disclose education records to the welfare agency, as well as the parents, of course. And at the end of this trial period, the CDWA will close the child's case. At that point, the school cannot continue to disclose education records to the child welfare agency.
Well, great. I want to thank our presenters, Bill, Elizabeth, and Taffy, for taking the time to do this webinar today. And I want to thank our participants for being on today's webinar. We trust that this has been helpful. Should you have further questions on this or any other related topic, please don't hesitate to look at the various resources on the PTAC website. That information is listed on this page. And if you still need assistance, please send us an email at the email address listed here. In addition, you can sign up for the PTAC listserv by going to the PTAC website and clicking on the Contact Us link, and then you'll be automatically notified of new ed/PTAC guidance around privacy and security and of our upcoming webinars. Thank you again for attending.